Sedaj pa kar začnimo. Besedo predajam magistru Dejanu Židanu, državnemu sekretarju na Ministrstvu za gospodarstvo, turizem in šport. Izvolite.
Iz Ljubljane. Vse verjetno nekaj ste slišali na začetku. Poleg vseh sodelujočih sem želel posebej pozdraviti kolege iz Evropske komisije, iz Francije, Nemčije in Slovaške, ki ste se prijazno odzvali našemu vabilu. To nam veliko pomeni in res najlepša hvala. Pridobili ste si dodatne prijatelje v Sloveniji. V Sloveniji smo konec lanskega leta v resnici dosti na silo sprejemali dva tako imenovana avtorska zakona zaradi zamud pri implementaciji evropskih direktiv. Samo sprejemanje ni bilo enostavno, je povzročalo dosti tenzij v specializiranih javnostih in takrat smo dali dve obljubi. Ena od obljub je bila dana, da ob ugotovitvi, da Slovenija še nima lastne strategije varovanja intelektualne lastnine, da bomo pričeli z medresorskim načinom pripravljanja te strategije. To sedaj poteka in imamo cilj, da pridemo prvič v zgodovini, ki je dolga več kot 30 let, lastne države, do lastne strategije varovanja intelektualne lastnine, ob zavedanju, da se to področje še vedno, sedaj pa zlasti zaradi vseh možnih aplikacij, ki jih prinaša hitrejši razvoj umetne inteligence, kakor smo pričakovali, prinaša, torej, da pridemo do lastnega dokumenta. Hkrati smo dali obljubo, da bomo odprli širši prostor za razpravo o avtorskih pravicah, sorodnih pravicah, saj samo ministrstvo ni razumelo, zakaj so tako zelo velika nasprotja med deležniki, ki jih vse po vrsti cenimo. To razpravo smo pričeli, imeli smo tudi prvo veliko srečanje v prostorih pravne fakultete, ki je pa vsaj meni pokazalo, da nujno potrebujemo dodatne informacije, kaj se dogaja tudi drugod v Evropi, da ne bomo mogoče iskali odgovorov na vprašanja, ki so jih naši sosedje že našli, ali pa v bistvu, da bomo tam, kjer so nejasnosti, da jih bomo skupaj reševali. Zato je bila želja, da se srečamo, kar je lažje preko digitalne povezave, s kolegi iz Evropske komisije, s prošnjo, da nam povedo, kaj počno na tem področju in zakaj to počno. Hkrati pa smo se dogovorili za 4, uspelo nam je potem, da smo realizirali za 3 državami, torej za Francijo, za Nemčijo in Slovaško, da nam povedo, kaj počno v njihovih državah, vse z namenom, da pridobimo dodatne informacije v slovenski prostor. Temu je namenjeno današnje srečanje, ki bo trajalo 3 ure. Ne bo pa to zadnje srečanje, to vrstno, ker pridobivamo v Slovenijo dodatne informacije, se bo tudi relativno doglednem času naslednje, ki bo pa bolj poudarek na upravljanju kolektivnih avtorskih pravic. Torej še enkrat, spoštovani in spoštovani, hvala, da ste danes z nami. Seveda ni pričakovati, da bomo danes našli vse rešitve, je pa to zame eden od potrebnih korakov, da pridemo tudi na tem področju do nekoliko bolj konsenzualne družbe. Rad bi se tudi zahvalil Uradu za intelektualno lastnino, gospe direktorici, pomočnici in vsem ostalim, da ste operativno to pomembno srečanje organizirali. In zaključim takole, veselim se današnjega druženja. Hvala, da ste me poslušali.
Najlepša hvala, gospod Židan. Sedaj pa prosim za uvodne besede magistrico Karin Žvokelj, direktorica Urada za intelektualno lastnino.
Spoštovani, lepo pozdravljeni v imenu Urada Republike Slovenije za intelektualno lastnino in tudi v mojem imenu. Zelo smo počaščeni in veseli, da danes gostimo strokovnjake iz Evropske komisije in tudi strokovnjake iz držav Francije, Nemčije in Slovaške, ki nam bojo predstavili ureditev na dveh področjih, kot omenjeno. Se pravi, v prvem delu se bomo dotaknili izjem in omejitev avtorske in sorodnih pravic na področju šolstva, raziskav in znanosti. V drugem delu pa se bomo dotaknili odprte znanosti, predvsem v povezavi z avtorsko pravico, kjer imamo, kot vemo vsi skupaj, kar nekaj odprtih vprašanj. Dva strokovnjaka iz Evropske komisije smo povabili zato, da slišimo, kako so ta vprašanja urejena oziroma kako bodo v prihodnje urejena. Bi pa rada predstavila posamezne strokovnjake. Z nami bo najprej v prvem delu gospod Kristof Mihčinski iz Generalnega direktorata komunikacijskega omrežja, vsebine in tehnologije Evropske komisije, in sicer enote za avtorsko pravo. Kot pravni strokovnjak opravlja različne projektne in politične naloge na področju usklajevanja zakonodajnih in pravnih vidikov. Trenutno prispeva k razvoju in izvajanju političnih pobud na področju avtorske in sorodnih pravic, vključno z izvajanjem reforme avtorskega prava iz leta 2019. Deluje tudi na področju prilagajanja okvira avtorskega prava podatkovnemu gospodarstvu ter medsebojnemu vplivu med avtorsko pravico in novimi tehnologijami. Dobrodošli. V drugem delu, ko se bomo dotaknili odprte znanosti, pa bo z nami gospa Alea López de San Román iz Generalnega direktorata raziskave in inovacije Evropske komisije, in sicer iz enote odprta znanost. Gospa López de San Román kot pravna strokovnjakinja prispeva k razvoju in izvajanju politike Evropske unije o odprtem dostopu do znanstvenih publikacij in raziskovalnih podatkov. Dobrodošli. Za sodelovanje smo prosili, kot že rečeno, tudi 3 države, kjer smo upoštevali 2 vidika. Prvi vidik je prostorski, drugi pa je različna ureditev na posameznem področju. Francijo kot predstavnica Sredozemlja, Nemčijo kot predstavnica centralne Evrope, po kateri se tudi naša zakonodaja pogosto zgleduje, in Slovaška, ki je enako kot Slovenija postala članica Evropske unije leta 2004 in se je razvijala podobno kot Slovenija. Pridružila se nam bo gospa Anne Lemervin iz francoskega ministrstva za kulturo. Gospa je vodja Urada za intelektualno lastnino in ima bogato znanje in izkušnje na področju avtorskega prava. Dobrodošli. Iz Nemčije bo z nami dr. Sophie Neumann iz Zveznega ministrstva za pravosodje. Dr. Neumann je zaposlena v oddelku, ki je pristojen za avtorsko in založniško pravo, je pravna strokovnjakinja, ki se ukvarja z avtorskim pravom. Iz Slovaške pa se bo pridružil dr. Jakub Slovak iz Ministrstva za kulturo Slovaške republike. Dr. Slovak je vršilec dolžnosti direktorata oddelka za avtorsko pravico. Skoraj vso poklicno pot se ukvarja z različnimi vprašanji povezanimi z avtorsko pravico in drugo intelektualno lastnino. Pripravlja zakonodajo in je aktivno sodeloval pri pripravi novega slovaškega zakona o avtorski pravici ter nadaljnjih spremembah. Že zdaj najlepša hvala vsem, da boste z nami delili bogato znanje in izkušnje. Prepričana sem, da bomo danes zelo dobro izkoristili ta dan z vašimi znanjem, izkušnjami in da bomo tudi izvedeli kaj novega. Zdaj pa predajam besedo moderatorici Petri Boškin, da nadaljujemo z našim programom.
Najlepša hvala. Sedaj pa predajam besedo gospodu Kristofu Mihčinskemu z Evropske komisije. Izvolite.
Hello, good morning everyone. I hope you can hear me well. Thank you very much for your kind invitation. Pleasure to be here. And can you see my presentation or put it on? Yeah, there it is. So maybe we can move to next slide, please. So the second slide. Yes, so today I would like to present to you few exceptions in the EU copyright framework that can be useful in the area of education and research. And as you very well know, under EU copyright law, the owners of copyright are granted copyright protection in the form of set of exclusive rights, like reproduction right or right to communication to the public or distribution right. But at the same time, the EU legislator has been mindful to find a balance between the role of users, especially in the area of education, research, and science, and the copyright owners. And to this end, actually, 3 directives contain some key provisions on exceptions and limitations. And this is the directive, so-called Information Society Directive, so one of the main copyright directives from 2001. Directive on the legal protection of databases, which we call Database Directive, and of course the recent directive from 2019, so the directive on copyright and related rights in the digital single market. Next slide, please. Yes, so especially important is the Information Society Directive that sets out exclusive list of exceptions and limitations to exclusive rights. And several of these exceptions are really relevant to the to those interested in reusing basically works and other subject matter for scientific purposes or for educational purposes. And the most obvious of these exceptions is the one for the purpose of teaching or scientific research from Article 5.3a. And this article provides for non-mandatory exceptions, like most of the exceptions actually in the InfoSoc directive, for the sole purpose of illustration for teaching or scientific research. The notion of teaching is not defined in the directive as such, but it should be understood not only or not limited itself to the use of works by teachers, but should also cover works that are used by students and pupils during their courses or classroom lessons. Illustration, the other condition, is also not defined as such, but we should apply ordinary meaning, which means that the work is used to clarify something or as an example or comparison. And what is quite important, and contrary to teaching purposes, the requirement of illustration seems not to apply to scientific research, but this is sometimes considered as controversial or uncertain by commentators, especially then the different interpretations, legal interpretation and language interpretation version might differ. Otherwise, this exceptions is worded in quite open-ended manner, and it does not give specifications or limits in a way on the beneficiaries or work concerns. Therefore, the exception actually can be used by institutions providing teaching or doing research, as well as individuals. Regarding the authorized acts, this exceptions allows, or again, because it's not mandatory, so allows member states to adopt exception to reproduction right, but also communication to the public, and also it covers acts of distribution. Important requirements is that the only acts accomplished with a non-commercial purpose can benefit from this exception. Another requirement, the source, including authors' names, should be indicated unless it turns out to be impossible. And again, like most of the exceptions from the Information Society Directive, it has non-mandatory nature, which has meant actually that it has been subject to differing and various interpretation and implementation in national laws. Next slide, please. Yeah, so to the extent that the previous exception, so teaching and research, does not apply or is not available sometimes in member states, a little bit of room for the reuse of scientific publications, especially may be provided by this exception, so general purpose exception for quotations. And this is because the purpose of education and teaching and research is generally one of the motives justifying the quotation. The concept of the quotations under EU copyright law is broad, and it can be done for any purpose, actually. Criticism and review are offered as indicative examples. And also what is quite interesting is that this provision is not subject to a non-commercial conditions. So the exception is partly broad, but also sometimes narrow because it's accompanied by many conditions. So one of them is that the use of the work must be fair. Again, there is no legal definition of what is fair or unfair in this context, and it will be ultimately up to the court discretion based on the individual facts and case-by-case basis. Another condition, the source needs to be indicated. However, again, there is no need to include acknowledgement if that would be impossible for reason of practicalities, basically. Also, the extent of the exception is limited because you can use the exceptions, so to speak, no more than what is required for the quotation. And what is the perhaps most important quality of this exception is that quotation is possible only if relates to a work which actually has been already lawfully made available to the public. Next slide, please. Yeah, so here is another optional exception from the Information Society Directive that can be relevant in some cases for teaching and research, and this is the exception for so-called on-site consultation. And these exceptions enable consultation of some works on the premises of publicly accessible libraries, educational establishments, or museums, or archives, but importantly by dedicated terminals, and that can be either the works in original form or in a digitized form. So therefore this exception is limited, so to speak, by spatial, so within the premises of these institutions, and technical restrictions, which are, to be honest, quite outdated because the consultation should be done through these dedicated terminals, basically located on the physical premises of this cultural heritage institutions. So there are further two other conditions for this exception. So first, the works that are offered for viewing on site should be contained in the collections of this cultural heritage institutions. And the second condition basically exclude from the benefit of the exceptions works that are subject to purchase or licensing terms. So in fact, this condition means that the exception can be contracted out. And finally, this directive, Information Society Directive, allows this communication or making available, but only restricts this to the individual members of the public. Next slide, please. And here is actually the only exception out of, I think, 21 or 22 from the Information Society Directive that is actually mandatory. So therefore, it can be found in all national laws of basically every member state. And so it's exception for temporary acts of reproduction. And researchers and other users of scientific publications especially may also be able to rely on these exceptions. And according to this exception, under certain quite carefully constructed conditions, basically the creation of copies of works doesn't infringe the reproduction right. So here it's important to understand that the scope is limited to temporary reproductions, which should be either short in duration or incidental, also with no independent economic significance. And in essence, in order to enter within the scope of this exception, a reproduction or the copy has to be necessary for the completion of the technical process and should be part of it. Also, it should be deleted automatically after a certain period of time. So common examples also mentioned in the directive are caching and reproduction that enable the act of browsing basically through the browser. Therefore, like copies created on screen or in the memory of the computer while browsing the internet qualify for this exception, and that confirms, among other things, of course, that users can read scientific publications, for instance, or educational materials using digital means, and that would not infringe copyright. But as this is temporary act of reproduction, so kind of by definition, this exception does not extend to storage of permanent copies, basically. Next slide, please. Yes, so database directive is quite an interesting directive that is that creates kind of two-tier structure of intellectual property protection for databases. First, it's for original databases through copyright, and secondly, more interestingly, it creates so-called sui generis right protection for non-original databases, assuming then investment in obtaining, verifying, and presenting data was substantial. And this sui generis protection is typical for EU and very unique on a global scale. And basically, the sui generis grants maker, so-called maker of the database, two categories of rights. One is to prevent extraction of the material from the database, and this is basically similar to reproduction, so copying database. And the second right is to prevent so-called reutilization of the part or substantial part of the database, which is equal to making available. And database directive allows exceptions for teaching and research, like the Information Society Directive, the exception I mentioned, both for copyright and sui generis part. However, this teaching and research exceptions in two parts is mostly identical, except one quite crucial point, because the sui generis part, for the sui generis part exception is limited only to extraction, so reproduction and no reutilization, so not making available, while the copyright part of the directive is broader and also includes this reutilization, so making available. And here it creates again a little bit of controversies, because basically sometimes it is considered like not very useful for, especially for researchers, if they cannot make available and share the results of their work. So again, the exception for the sui generis part, which is the most important part actually of the database directive, much more important than the copyright part, is therefore more restricted. And on top of this, there are these three cumulative conditions, which are very similar to what I described in the Information Society Directive. So there must be an illustration for teaching, the source must be indicated, and the exception, the use needs to be for not a commercial purposes. Next slide, please. Yes, so this is the very recent, obviously, development, and I'm sure you've all heard about this a lot. So this is the DSM directive, which actually comprise an TDM exception, and the directive actually comprises of two mandatory TDM exceptions. So first of all, it is really important to understand then we have mandatory exceptions, so very different than what was previously the case, where exceptions were not mandatory, creating quite a bit of unharmonized approach to exceptions. This exception is mandatory, and one from Article 3 is the exception for scientific research, and then we have much broader from Article 4. And obviously, these exceptions were introduced because TDM has become a hugely important research tool in science and many other domains, including in the development of AI, which is obviously recently a very hot topic. And we can even say then these articles are kind of European framework for AI development. So Article 3 requires member states to introduce a mandatory exception for acts of reproduction and extractions, again for the TDM purposes by research organization and cultural heritage institutions. And also directive allows that these institutions can securely storage copies of basically mined works. So the beneficiaries are clear, and exception from Article 3 is limited to research organization and cultural heritage institutions. But the directive also clarifies that not only these institutions can make the reproduction or extractions for the TDM purposes, but also individuals attached to them. So, for instance, data scientists. So what are the conditions for the exceptions to be exercised? Cultural heritage institutions and research organizations, as well as I mentioned, individuals attached to them, need to have lawful access to the material being mined. And its lawful access is a little bit explained in the directive, and for instance, content freely available online qualifies as lawful access. What is also important, directive expressly provides that any contractual provisions contrary to the exceptions are unenforceable. It also clearly states that these exceptions will not cause harm to the right holders and therefore is not subject to remuneration. Next slide, please. And Article 4 from the DSM directive is introducing general, as we call this, general text and data mining exception, so much broader exception, which basically permits TDM for all purposes, regardless of underlying commercial motives. It is also broader because it can be enjoyed by anyone. So there is effectively no restrictions on beneficiaries, like in the first one, where, as you remember, cultural heritage institutions and research organizations were beneficiaries. So for this one, commercial research labs, AI, commercial developers, other private companies or individuals can actually take advantage of this broader TDM exception. And the biggest difference in comparison to the previous research exception from Article 3 and this one, general TDM exception, is the fact that directive allows right holders to opt out of this broader exception. So the exception basically applies only on condition that right holders have not expressly reserved their rights, and also directive says then it should be done in an appropriate manner, which for content publicly available online needs to be done in machine-readable format. And similarly to the first exception, a prerequisite is that the organization has lawful access to the material being mined, and also this exception is not subject to remuneration. Next slide, please. And finally, the exception from Article 5 of the DSM directive, which is exception for digital and cross-border teaching. And again, this is a mandatory exception, and the introduction of this new rule, first of all, was intended to clarify the application of teaching exception in the digital environment, and it also extends actually the application with the cross-border element. Regarding beneficiaries, Article 5, so this exception is reserved for teaching activities under the responsibility of education establishments. And the term is not defined in the directive as such, but it is indicated in one of the recitals that it's an education establishment within the meaning of the directive. Need to be recognized by a member state. So that also shows that this article gives a lot of flexibility to member states. This is one of the examples, because they can actually, in their national legislation, clarify what is understood on the national level by educational establishment. And as I said, the exception applies across borders. I mean, within all EU member states, and that's done thanks to a legal fiction, which basically stipulates that uses under these exceptions are deemed to take place in the member states where this educational establishment is established. Like with many exceptions, except maybe the TDM broad exception that I mentioned, the uses covered by this exception should be justified by the non-commercial purpose of the teaching activities. Regarding these digital uses that are allowed under this particular exceptions, on the one hand, uses of protected content made in the classroom or other venues through digital means are allowed, but on the other hand, uses made at a distance, but that should be done through secure electronic environment, and more on that is also explained in the directive. And in most cases, it should be enough that only small parts or extracts of the work should be enough for this teaching purposes, for using this exception. But again, here, directive gives member states flexibility, because member states can specify for different type of works even the proportion of the work that can be used under this particular exception. And another flexibility that directive gives to member states is the room for deciding whether the exception apply or not, where the licenses for the works are available on the market. However, if the member state decides that exception doesn't apply when licenses are available, such licenses should be easily available in the market, as directive points out. And it's in the sense that it should not require huge effort for these educational establishments to find out whether there is a license or not available for a given work. So it should not compromise basically the effectiveness of this exception, or make the life of the educational establishments even more difficult. And again, similar condition as in some previous examples. Unless impossible, the source of the work must be indicated, including the name of the author. So next slide, please. Yes, I believe that's all, and end of my presentation. Thank you very much again for your kind attention.
Najlepša hvala. Sedaj pa k besedi vabim gospo L. Morvon z francoskega ministrstva za kulturo. Izvolite.
Yes, morning. Do you hear me? Okay. Thank you a lot for inviting me. Okay, since the Commission presented already the legal framework, I will sometimes recall a bit what the Commission has said, but I tried to focus a little bit more on the specificities we have in our legal regime, because yes, as the Commission said, the last exceptions set out in the DSM directive are mandatory, and the conditions are pretty well described and compulsory for all the member states. So there was not a lot of room of maneuver for the member states. That's why I will try to focus as much as possible on yes, the special things, so to say, we have. Okay, let's start by the context. In France, we had implemented already the educational exception while we implemented the InfoSoc directive. So we have an exception for schools and universities since 2006 in France. So that is going to be my first point. As we were discussing on the implementation of the new exception from the DSM directive, the choice was made to keep the former one, so which covers both education and research for purposes of illustration of the teaching and the research, and to add a new exception with the conditions and scope of the one set up in Article 5 of the DSM directive. So to say, we have two exceptions for education, the former one from the InfoSoc directive plus the new one from the DSM directive. And so we kept also the one from the InfoSoc directive for research. Okay, and I will explain a bit more on that, but I wanted to present you the frame of my intervention. So besides this implementation of the new educational exception, we naturally also implemented the new exceptions for TDM. And I wanted to also tell you a bit about something else we had at the same time. We had a big demand from the Ministry of Research that the researchers could use images to illustrate the publications of their research, and they were asking us to have an exception. And then there was a big discussion, because we said actually the EU framework has a list of exceptions, and we cannot go beyond. So after a lot of discussions with that ministry, we ended up with having a new solution, which is to use the extended collective licensing possibility of the DSM directive in order for the researchers to be in a capacity to use the images they need for the publications of their research results. So let's start with the first exception I talked about, which is maintain of the exception for educational and research purposes from the InfoSoc directive. So I have slides which you can have afterwards, but sorry, I communicated them a bit late, so it's not available at the moment. So naturally, we do have implemented the same conditions as Christoph just explained, which is it's covering excerpts of works. It's for the exclusive purpose of illustration in the context of teaching and research, including in France material for exams. It's intended for an audience consisting mainly of pupils, students, teachers, or researchers, as the exception provides for. Naturally, you have to cite the source whenever you can, and it's for non-commercial purposes. Maybe something which is a bit different in France than in other countries is that the scope of the works has been set up quite precisely, as it was organized in the directive. It's all works except musical scores. That was the EU framework, but it's also all works except works conceived for educational purposes. Our idea was, since these works are drafted for educational purposes, the main market is educational purposes. And so if you have an exception on that, you won't give the chance for the authors or for the publishers to recoup their investment. So we sorted out these works from the scope of the exceptions. Then comes the question of whether the exception is compensated or not. Actually, it is. The French law says that it is compensated with a flat rate base, on a flat rate basis. Actually, it's mainly because of the historical context of this exception that we ended up in that. Initially, the French government didn't intend to have an exception for education and research. And while we were discussing on the implementation of the text, some negotiations were taking place parallel to that between the ministries of education and research on one side and the CMOs on the other side. And actually, well, the negotiations from the private sector ended up at almost the same time as we were in the parliament. And then an amendment was presented transforming the result of the negotiation into an exception in the law. So I'm not sure I was precise, but somehow in the law we have the result of this negotiation. And the result of this negotiation is it is compensated, but in the way that it means that the payment of a remuneration is the condition to have the exception. So if there is no agreement on the amount, then there is no exception. And the result is also that because you still have agreements, so on a 3-year basis, so every 3 years, the ministries and the CMOs are negotiating. You have in this agreement not only the amount to be paid by the ministries to the authors and publishers and producers, but you also have added uses, because the teachers and researchers have actually said that the exception was not enough to cover their needs. And so besides the exception, you have in the agreements also uses which go beyond the scope of the exception, and they are remunerated. So it's a bit of a mix between the exception compensated plus other uses that are needed, which are remunerated. And so you have one agreement covering the use and reproduction of books, published musical works, periodicals, and works of visual arts, and another agreement which is covering music and audiovisual. So almost all the works actually can be accessible to the teachers and the researchers, but there are two agreements covering all the sectors. And the last time actually an agreement was made, it was in 22, so it's a quite recent one. So then I will go back to my second point, which is the addition of the new exception to implement Article 5 of the DSM directive. The Commission has already presented the scope of that exception. Naturally, we implemented, and we hope we haven't forgotten anything, but we have implemented all the conditions, which means it's concerning extracts of work. It is again for the exclusive purpose of illustration in the context of teaching and vocational training, which was in the case in our previous exception. Still also all the works needed to prepare for an exam or to pass an exam, actually. And it's covering the uses made on the premises or other places, but also by means of a secure digital environment accessible to these people, so pupils, pupils, teachers, as set out in the directive. We naturally implemented the legal fiction in case of a cross-border context. We have chosen to compensate this exception. We still have this flat rate basis principle. Naturally, as for the former one, when possible, the teachers need to indicate the source of the extract, and it's for non-commercial purposes. The Commission explained that it was a two-tiered system with the possibility, in case licenses were covering the needs of the exception, to give a prominent position to the licenses, and France has made the choice to adopt this faculty left by the directive. So in France, in the text, it is clearly indicated that the exception does not apply when adequate licenses authorizing these acts for purposes of illustration are visibly proposed to them. So I hope my phrase was a bit too long, so I tried to cut. I hope I didn't cut too much. So we do have this possibility to have licenses covering the needs in order for the educational establishment not to have to negotiate with too many publishers, for instance. And after long and large discussions with all the sectors, we propose that these licenses can be conducted through extended collective licenses. So the idea is to help out the educational establishments in having licenses as large as possible. And we also are trying to convince the right holders to organize themselves in order to propose 1 or 2 license per each sector. We don't have to want to have multiple licenses because it's not going to be easily readable for nobody. And the directive stated that the system has to be clear and effective for the schools. So that's the way we found to to respond to the conditions of the directive. Practically, we know in the music and the audiovisual sector, they're not interested in that. For them, it's easier to have the exception compensated. But we know that in the book sector and also for journals, newspapers, they would like to go into negotiations on the basis of extended collective licenses with the establishments of education. In order also to facilitate the life of the schools, we decided that the license, or a sort of a framework license, could be negotiated by the ministry itself. So not every school has to go to the publishers and ask for a license. There is a broad agreement negotiated by the Ministry of Education, and then each school can have a small agreement, but they don't have to negotiate anything. So the negotiation is going on at the moment, and I cannot tell you about the results, but that's the way we organized the things. Right, so I think I finished the ones on education, and then I will go to the exceptions we have for research. So as regard research, as I said, we still have the former research exception from the InfoSoc directive, which hasn't been changed. And we have the new one as regards TDM, which we implemented in, I don't remember, I think it was November, November 21. What can I say to that? Well, mainly because the directive is very much precise. We just had to take over all the conditions from the directive. So naturally, the TDM exception for research applies when works have been lawfully accessed by the researchers. The TDM is possible when it's carried out solely for the purpose of scientific research by research bodies and cultural heritage institutions. The research can be made on their behalf, but also at the request by other persons. If this other person is a non-profit partnership with private actors, and on that we had a lot of discussions. So we decided at the end that they could access to the TDM results when they didn't have a privileged access to that. Naturally, we had all of these conditions about the storage of the data and also the works, also on the possibility for the publishers to adopt proportionate and necessary measures in order to ensure the security and integrity of the network and database. We naturally also transposed that part on not possible to let the contract override the exception. But in our code, it is placed in another place, actually, and naturally, it's non-commercial. Maybe what is more interesting is we added a clear invitation in the text indicating to the stakeholders that they had the possibility of an agreement to define the good practices in that area. So we didn't know exactly how to draft it, because normally legal rules are binding, and so we found a way to say that it was possible. So they were strongly politically invited, but it's not compulsory because it would be an added condition. But we clearly say, if you go to an agreement to define good practices, that would be a good way of doing the things. And as far as I know, well, actually, I have no news about that. So I don't know if they're defining good practices at the moment. Right, and then I think I finished by that. I hope I wasn't too long. It was this fourth sort of, not exception, but legal way to help researchers publishing their publications. So since, well, actually the same secondary legislation by which we implemented the DSM directive, we added a new article saying that exclusively for the purpose of illustrating publications or work disseminated online without a restriction of access as part of a research and higher education activity, the researchers were able to use all the images they needed in that purpose, according to licenses, negotiated between the Ministry of Research and the CMOs concerned, and that agreement could be extended to all works concerned. So that's another way to take advantage of the last European directive, which allows the member states to have to have extended collective licensing. And we thought in that era, it was a special case where the normal negotiation is too complicated and cannot lead to cover all the images they needed. So we decided to use this ECL system in order to respond to the needs of the researchers. And as I listened to the Commission, I also noticed that I had forgotten, but we also transposed in 2006 this exception on on-site consultation in cultural heritage institution. And in our we have three main cultural heritage institutions which have the legal deposit. So it means that they have mainly all the works published in France. So may they be audiovisual or musical or well, just books and newspapers, and they all give special access to accredited researchers in order for them to complete their researches. And thank you a lot for listening, and I think I have finished.
Najlepša hvala. Sedaj pa besedo predajam gospe Zofie Neumann z Nemškega zveznega ministrstva za pravosodje. Gospa Neumann, izvolite.
Thank you. And thank you for the invitation and the warm welcome. And now I have the pleasure to present you the German law. I will start with a few general remarks on the exceptions and limitations in the area of education, research, and science. So the current German statutory limitations in this area are all based on the Information Society Directive, in essence, and they essentially go back to a reform of 2017, which entered into force on the 1st of March of 2018. This reform replaced, consolidated, and extended pre-existing scattered provisions in this area that were mostly temporary and sometimes extended several times. Initially, the reform was limited to 5 years and was to be evaluated after 4 years. In 2021, things changed and the limitation was abandoned. And 2021 was also the year where the DSM directive was transposed into German law. And with this directive, a few modifications and extensions were adopted in German law. The basic idea of the German statutory limitations is to legally guarantee a minimum access by statutory limitations to content protected by copyright. So these statutory permitted uses are not complete and they are complemented by licenses. Licenses continue to exist and are not void. However, as a general rule, right holders may not invoke agreements which restrict or prohibit statutory permitted uses to the detriment of the persons entitled to such use by law. As a compensation for the statutory permitted uses of the works, rights holders are generally entitled to an appropriate remuneration. So only few uses are accepted from remuneration. Thus, their property interests of the right holders, which are also protected by the Constitution, are safeguarded. And the idea of remuneration also results from the three-step test anchored in EU law and also in international law. And it contributes to a fair balance of interests of the right holders and of the users. So the German law has decided to create specific permissions for specific user groups and institutions in the area of research and education. The beneficiaries and the scope of the permitted uses are precisely described in the text of the law. A general fair use provision for education, research, or science does not exist in German copyright law. In section 60A of the German Copyright Act is the limitation for teaching and educational establishment. The basis in EU law is Article 5, Para 3, Littera A, and Para 4 of the Information Society Directive, and Article 5 of the DSM Directive. Actually, Germany defined what is an educational establishment, which was left open to the member states, as we heard from the Commission. And an educational establishment, according to German law, means early childhood educational establishments, school, universities, vocational schools, and other training and further education institutions. As to the beneficiaries of the statutory limitation, it addresses to teachers and participants at the respective event, teachers and examiners at the same educational establishment, third persons for the purpose of presenting lessons or lectures, or the results of tuition or training or learning outcomes at the institutional establishment. For example, if a school makes a day open to families and potential further students, they are allowed to present their educational activities. As to the scope of permitted uses, covered are the reproduction, the distribution, the making available, and the communication to the public of 15% of our published work. The scope of 15% is supposed to specify the requirement of the Information Society Directive, which demands to the extent justified by the non-commercial purpose to be achieved, and of the three-step test. It also follows previous practice and jurisprudence concerning the notion of small parts of a work in German law. Uses are further allowed is the full use of an illustration or of an individual article from a professional scientific journal or of an out-of-commerce work for educational purposes. And the purpose is specified to be the purpose of illustration in teaching in educational establishments on a non-commercial basis. Some uses are also accepted from the scope of permission. There we have the reproduction of a work by means of the recording onto video or audio recording mediums, or the communication to the public of a work whilst it is being publicly recited, performed, or presented. And a further exception to the limitation, actually it's quite similar to France, but limited to school books. So school books are accepted from this use when licenses are easily available, meet the needs and specificities of educational establishments, and permit uses as provided by the statutory limitation provision. If these conditions are fulfilled, the basis for the use has to be the license and not the limitation provision. Germany has also adapted the provision on localization of the DSM directive to solve cross-border aspects of online teaching activities. And as to the remuneration, well, in general, in German law, statutory permitted uses are always subject to remuneration unless some uses are specifically exempted from remuneration. And concerning the teaching limitation, we only have one exception from remuneration, referring to the communication to the public for the benefit of members of educational establishments and their families, with the exceptions of making the content available to the public. So this covers actually the performance of a play or a song at a school festivity at the end of the year, for example, but not the making available of that performance. Then German law has also a limitation enabling the production of media collections for teaching. Then we have in section 60C a limitation for scientific research, which is based on the Information Society Directive. Beneficiaries of this exceptions are researchers, students for their own scientific work, but also private experts that engage in research. As to the scope of permitted uses, allowed are the reproduction, the distribution, and the making available to the public of 15% of a work for the purpose of non-commercial scientific research. For his or her own personal scientific research, a researcher may reproduce up to 75% of a copyright protected work, but only the right of reproduction is covered there, not the other rights. And full use may be made of an individual article from a professional or scientific journal, or of an out-of-commerce work for research purposes. Some uses are also accepted from the scope of permission, and there we have the recording of the public recitation, the performance or the presentation of a work onto a video or audio recording medium, and the subsequent making available to the public of that recording. Also, the uses in research are subject to remuneration in German law. Section 60D of the German Copyright Act then contains a limitation for text and data mining for scientific research purposes. German law also contains a broader and more general TDM provision, as is provided for in the DSM directive, but I will focus on the one for scientific research purposes, as is today's topic. The EU law basis is again Article 5 of the Information Society Directive and Article 3 of the DSM directive. Beneficiaries of these limitations are research organizations, so universities, research institutes, and other establishments conducting scientific research, if they pursue non-commercial purposes, reinvest all their profits in scientific research, or act in the public interest based on a state-approved mandate. Libraries and museums, insofar as they are accessible to the public, and archives or institutions in the field of cinematic or audio heritage, so cultural heritage institutions, individual researchers, insofar as they pursue non-commercial purposes. As to the scope of the permitted uses, covered are reproductions to carry out text and data mining for scientific research purposes. And also, and their German law is based not for this specific use on the DSM directive, but on the Infosec directive, the making available of the reproductions to a specifically delimited circle of persons for their joint scientific research and individual third persons for the purpose of monitoring the quality of the scientific research. The uses or the permitted uses are subject to a limitation in time. So the making available to the public must be terminated as soon as the joint scientific research or the monitoring of the quality of the scientific research has been concluded. Organizations may retain reproductions, thereby taking appropriate security measures to prevent unauthorized use for as long as they are needed for the purposes of the scientific research or the monitoring of the quality or of the scientific findings. And according to EU law, right holders are authorized to take necessary measures to prevent security and the integrity of the networks and the databases. As to the remuneration, so we have an exception from remuneration regarding the reproductions made in the context of text and data mining for the purposes of scientific research. German law thereby follows the recommendation contained in the recitals of the DSM directive. Regarding the making available, this exception from remuneration does not apply, so the making available is subject to remuneration in German law. The German Copyright Act then contains two limitations destined to libraries on the one hand and to archives, museums, and other cultural heritage institutions on the other hand. These limitations basically allow the reproductions for making available, indexing, cataloging, preservation, and restoration, which are also provided for now in the DSM directive. And it also contains the online consultation limitation, which was presented by the Commission and also in French law. And no surprise, also Germany has this online consultation use in libraries and in archives and cultural heritage institutions. As to remuneration, so also here, remuneration applies as a general rule, and we have an exception from remuneration for reproductions for the purpose of preservation and for the purpose of indexing, cataloging, and restoration. And so after having introduced these limitations in German law, I will spend a few words on the evaluation of this law, which was conducted in 2021 and 2022. And actually it was one of the tasks I was attached and assigned to here at the Ministry of Justice. So I mentioned at the beginning, the reform initially was limited in time and it was subject to an evaluation 4 years after entering into force. This evaluation was conducted in 2021 and 2022, and the evaluation report was presented by the German government in May 2022 and then submitted to Parliament. Basis of the evaluation was the broad stakeholder consultation in Germany. And as to the main outcomes, so in principle, the reform appears successful. There were no indications of serious problems with the application of the statutory limitations in the area of education, research, and sciences. Apart from that, the heterogeneous interests of right holders on the one side and users and beneficiary institutions on the other side persist, especially with regard to the scope of the permitted uses, as well as with the determination and the amount of the remuneration. So users of the statutory limitations and the respective institutions consider these statutory permitted uses or limitations to be essential and advocate some extensions. Right holders and especially publishers considered the statutory permitted uses to be already too broad and argued that the big business was affected. As to the remuneration, so the remuneration in Germany is negotiated between the collective management organizations on behalf of the right holders and the federal and regional states on behalf of the education, research, and cultural heritage institutions. And so, although remuneration is not contested in principle, there are some aspects that remain contested and where no agreement has been reached so far. So unlike France, we do not have the agreement on remuneration as a precondition, but actually institutions also in the teaching environment may start using, but still some payments have to be made. And so we have a situation in the area, especially of research, where there have been uses, but that no agreement has been reached so far. But of course, these uses that have actually taken place are to be remunerated. And that would end actually my presentation on this behalf. Thank you for your attention.
Najlepša hvala, gospa Neumann. Sedaj pa besedo predajam gospodu Jakobu Slovaku iz Slovaškega ministrstva za kulturo. Izvolite.
Thank you very much, and good morning to all. Thank you very much for the invitation and for being part of this event. I would like to present you the situation of exceptions and limitations in the area of education, science, and research in Slovakia. And if you allow me, I would like to share the screen with a small presentation in a minute. Please, can you confirm that you can see the presentation already on the screen? Okay, thank you very much. So in general, I would like to start with a few general rules for all exceptions and limitations that are in our Slovak Copyright Act. The exceptions and limitations are regulated in the 4th chapter of the Copyright Act. And some of these exceptions are recently quite new because they are based on the DSM directive. Some are based on the old InfoSoc directive, and some are historical. It means that they were in previous copyright acts and proved to be useful in practice. So they state in the Copyright Act. Of course, it's important to say that Slovakia has already transposed the DSM directive. The amendment of Copyright Act was approved last year in 2022, and it's in force as of 25th of March 2022. So it's already more than 1 year when the DSM directive is was implemented into Slovak Copyright Act. Before establishment of any exceptions and limitations, also the ones that are derived from the DSM directive, we held consultations with stakeholders. There were large scale of stakeholders, for example, CMOs, libraries, publishers, research centers, right holders associations, users, or internet platforms. So during the National Working Party, we consulted the exceptions and limitations and also other parts of the Copyright Act, for example, collective management of rights or licenses. But as our topic today is focused on exceptions and limitations in the area of research, science, and education, I would like to continue with this part. Every exception, of course, as has been many times pointed out by the previous speakers, has to be interpreted in line with 3-step test. In general, it has been emphasized many times within the consultations that every use that goes beyond the three-step test or beyond the purpose of certain exception or limitation should be licensed. So that's the basis, and every exception has to be still interpreted in line with this three-step test. Of course, there is another condition for exceptions and limitations. Once again, it was already pointed out that if the nature of the work and its type of use allow it, a name of the author or its pseudonym, as well as the name of the work and source has to be indicated on the work. There are some exceptions. The general rule is that exceptions and limitations cannot be overridden by contract, but there are two cases in the Slovak Copyright Act when some kind of override is allowed. First case is the general text and data mining exception, because there is a form of a reservation or opt-out, as Christoph pointed out. And the second case is the exception for use of work by technical device or by so-called terminal in the premises of library, archive, museum, or school, if it's not contrary to the conditions of use of such work set by the library, archive, museum, or school. So if these institutions have some internal document which specify some possible reservation or some conditions of use, then it can somehow block this exception, let's say. Another general rule and very important rule is that all exceptions and limitations related to education, science, and research are without payment of remuneration to the authors or without the payment of compensation of remuneration. So large scale of exceptions and limitations in Slovak Copyright Act is without payment of remuneration. There are only private copying exception and reprography exception that allows for some kind of compensation of remuneration, but these two exceptions are not part of today's event and today's presentation. I would like to continue with the exception for use of work for education and research purposes. There are two important paragraphs in this exception in the Slovak Copyright Act. The first paragraph is quite general and it's based on the Infosec directive. In general, there are specified some types of use. So without authorization of the author, the published work is allowed to be used by making a copy, by public performance, or by communication to the public. The other condition is the purpose, that the purpose has to be limited to the illustration purpose when teaching or when teaching lessons or when doing research. And another condition is that such use of a work does not result in direct or indirect economic benefit. This was implemented in the Slovak legislation just after the transposition of the Infosec directive. Last year, there was a new paragraph aided by the already mentioned amendment of the Copyright Act that transposes the DSM directive, and a new paragraph reflects the situation of e-learning and distance learning practices. So once again, there is a general way of saying that copyright is not infringed by the person who, without the authorization of the author, uses the published work by certain types of use that are mentioned in this paragraph for the illustration purpose, but during the lessons in the school, under the school's responsibility, or through the secured electronic network of the school for non-commercial purpose. So this new paragraph includes three regimes. First is the use of a work directly in the school and in its premises. Then anywhere outside the school, but under the responsibility of the school, or in a so-called distance manner, it means that the work can be used without the authorization through the secured electronic network of the school, which means that, for example, teachers or pupils or students need some kind of access to the secured electronic network. For example, it can be protected by some kind of password or something like this. So that's for the general exception for the use of work for education and research purposes. And I would like to continue with one specific exception that was added into Copyright Act in 2016 based on the practical experiences and also based on the consultations with the stakeholders, but some kind of this exception was already in a previous Copyright Acts. So it's one of these exceptions that can be considered as, let's say, a historical one. Because during the consultations, we faced some problems when, for example, pupils and students were giving free of charge concerts or were singing for some kind of charity projects. So these are kind of examples that we are facing. So exception for use of work in school performances. In general, this exception has its wording that copyright is not infringed by a school or by their pedagogical employee. Of course, there are other employees of the school that can be considered as beneficiaries of this exception, who, without the authorization of the author, uses published work in a school performance organized solely by the school or by its founder. It means founder of the school. And the other condition is that this school performance has other purpose other than the direct or indirect economic benefit. Of course, there is a second paragraph in this school performances exception, because we also have the definition of the schoolwork in the Slovak Copyright Act, which means that the schoolwork is created by the pupils, by the students for fulfilling the duties of the school. So based on also some kind of practical experience, there was added very short paragraph 2 for this exception, and it says that a school which, without the authorization of the author, uses the schoolwork in the course of free of charge fulfillment of the school objectives and duties is allowed to do this. So when, for example, school is engaged into some competition where schools from every region present the best schoolwork, it can freely use the schoolwork. Or, for example, using the schoolwork as an example for other students. This is the main idea of this paragraph. Paragraph 2. With regard to the research, I would like to continue with the text and data mining exceptions that were mentioned many times here already. There is a general exception and, of course, specific exception related to text and data mining. In the text and data mining exceptions, we try to stick as much as possible to the DSM directive. So the general exception, of course, include the same conditions as indicated by the DSM directive. So there is no specific purpose. It's not limited to some specific beneficiaries. Use of a work can, without the authorization, can be done only by making a copy for text and data mining. There is, of course, condition of the lawful access, and author can make opt-out or the reservation. So he or she can somehow block the exception by this reservation or by this opt-out provision that is already included in the Slovak copyright law. At the same time, there is a specific exception for text and data mining, which is directly related to the research purpose, and it has a specific number of beneficiaries because copyright is not infringed by the library, archive, museum, school, or depository set by the law. So these are the specific beneficiaries. The depository set by the law, it's may seem a bit tricky, but it may include, for example, Film Institute or Academy of Science or some kind of research center that are set by the law. So these beneficiaries who without the authorization of the author uses the work are allowed to do it by making a copy for research purpose when doing the text and data mining. Of course, there are other conditions that are derived from the DSM directive. For example, the importance is put on the securing the data and their preservation of the data. So it's important to keep the integrity of the systems and the databases. And of course, the access to these systems and databases should be allowed only to authorized persons. So once again, it has to be somehow secured. Access. I would like to continue with some other exceptions that are can be only or that are slightly or can be only in some way related to science, education, or research. There are, for example, exceptions for the use of the work through terminal device or terminal equipment in the premises of library, archive, museum, or school. Of course, as was pointed out by Christoph, there can be a quotation exception or preservation exception. And one more thing that I would like to add is the exceptions that are related to databases. As was already pointed out, we have exceptions to copyright protected databases and exceptions for the sui generis right to databases. As regards copyright protected databases, there is a general provision that says that all the exceptions that are in the fourth chapter of the Copyright Act can be used appropriately. So it's based on some appropriation, or it depends on the nature of the database. So it's just a general provision. They are not expressly specified in this database part of our Copyright Act. Concerning the sui generis right to databases, it's very similar as Commission presented. We have extraction for illustration purposes when teaching or when doing research with regard to the sui generis databases. And there is also extraction allowed for illustration purposes when teaching in school, under school responsibility, or through secured network for non-commercial uses. So it somehow copied the wording of the exception and limitation, which is included in this part. So it's in this part of exceptions and limitations in this chapter. So the database provisions include very similar wording as, let's say, general exception that was transposed by the DSM directive. From my side, that's all for now, and I would like to continue then in the next part with some issues related to open access and open science. Thank you very much.
Najlepša hvala, Jakob. Prišli smo do konca prvega dela. Sedaj je čas za vaša vprašanja. Besedi se prijavite tako, da kliknete na gumb Dvigni roko. Tako da kar vabljeni k zastavljanju vprašanj našim gostom. Želi kdo morda zastaviti vprašanje? Nobene roke ne vidim. Vprašanj z vaše strani ni, saj nobene roke ne vidim na zaslonu.
Petra.
Morda
se
Maja
opravičujem.
Bogata-Jančič.
Najlepša hvala. Ja, najlepša hvala, Petra, ker me slišite. Maja Bogata-Jančič, se opravičujem, sodelujem preko telefona in nisem uspela pravega gumba najti dovolj hitro. Se opravičujem. Najlepša hvala za predstavitve. Jaz bi imela par vprašanj. In sicer imam 3 vprašanja za 3 govorce, lahko zastavim samo enega, pa potem, če ne bo drugega spraševalca, zastavim še naprej. Če mi dovolite.
Ja, seveda, kar prosim.
Prvo vprašanje imam za gospoda Krištofa Nečinskega iz Sorry, I will continue in English. So thank you very much for this opportunity. I will have 3 questions for 3 speakers, but I will only pose one at the beginning and then continue if there will be no other in the room asking the question. So thank you very much to Krištof Nečinski for a presentation from the side of European Commission. I have the following question. During your presentation, you mentioned that in respect to the TDM exception, there is a provision that allows lawful access means also all content available on web. This is, of course, this can be read from the arrest of number 14, but in Slovenian legislation, unfortunately, we were not able to achieve this. So the lawful access under the scope of TDM exception, according to Slovenian law, means only the lawful access which is generally defined in our copyright law, which means all rights reserved except specifically allowed by the right holders or under the scope of exceptions and limitations. So in this respect, our exceptions and limitations for TDM for research is a little bit more narrow. And actually, this is quite a huge difference because for TDM, it's extremely important that the open web can be text and data mined as well. So in this respect, my question is the following. What can Slovenian researcher and research organization, which is the beneficiary, can do now in these circumstances? Because according to our law, it is not allowed to text and data mine open web. So is this a situation to start court proceedings in front of the Court of Justice or anything else? Thank you very much.
Yes, thank you very much for these questions. Indeed, the directive is quite straightforward about this, and the content freely available online is one of the examples for lawful access. And as I mentioned, the TDM tool is considered also TDM exception as a framework right now for the AI development in EU, which is also obviously very, very important and depending, so to speak, on this to large extent on this content available online. So regarding the Slovenian legislation and choice made, it's very early stage, I must say, and I wouldn't like to take an decisive stand on this one, because we also in the Commission started very recently a separate independent study with a independent contractor on conformity check of national legislations with the DSM directive. So we give ourselves a little bit of time to check how member states implemented the DSM directive, and we will also look at all different particularities, including obviously this important provisions of for the TDM exceptions. So right now this is internally for the Commission the way to check whether the national legislation is in line with the directive. And once we have results of the study, we will then see what next, what can be done next. Regarding the individual researchers, at national level, then I wouldn't like to again take a position, but you can talk to your ministry, try to understand the reasons behind this. And maybe I see Moita also raised her hand. Maybe she can complement, say something more about this particular choice, the way the TDM was implemented.
Ja, hvala za pojasnilo. Predajam besedo Mojci Pečar.
Hvala za besedo. Jaz bi želela samo pojasniti, da je v zakonu v 57a členu in potem tudi v 57b členu ustrezen sklic, da, in citiram, za namene besedilnega in podatkovnega rudarjenja je prosto reproduciranje del, do katerih se zakonito dostopa. Potem se naprej še druge določbe, ampak želela bi poudariti, enako kot je v direktivi, imamo pogoj zakonitega dostopa, ki ni omejen glede del, ki so na spletu. Hvala.
Hvala. Hvala. Želi morda še kdo zastaviti vprašanje? Nihče? Rok ne vidim. Če slučajno bi kdo želel zastaviti vprašanje, naj se oglasi, ker rok ni. Če temu ni tako, predlagam, da imamo pauzo.
Jaz bi še, oprostite Petra, če ni nobenih drugih vprašanj, bi izkoristil. I would really like to use the opportunity to ask another question, if still possible.
Ja, seveda, kar zastavite vprašanje.
So, thank you very much, Maja Bogataj, again, Intellectual Property Institute. I have the question for Dr. Sophie Neumann. Thank you very much for your presentation. I will again ask you, my question will again focus on text and data mining. You explained the system in Germany, and you mentioned that you have the exception that covers also making available, but you mentioned that regarding the remuneration, even for the TDM exception regarding research, the making available part of TDM in your exception is not excluded for remuneration. And I would kindly ask if you elaborate more, and how do you base this understanding of your provision, your argumentation for this explanation? Thank you very much.
Yes, thank you for this question. Yes, so we have actually two aspects of TDM. As you just pointed out, we have the reproduction part and the making available part. As to the reproduction part, this part is now covered by the DSM directive. And for this part, the DSM directive, at least to our understanding, contained the recommendation not to subject the reproductions made in the course of TDM to remuneration. That is why this use was exempted from remuneration in light of the DSM directive. So actually, even prior to the DSM directive, German copyright law contained a limitation on text and data mining, which covered both reproductions and the making available of the results. And prior to the DSM directive, both uses were subject to remuneration. So actually, only in the course of the transposition of the DSM directive, the part which is now covered by the DSM directive was exempted from remuneration following the idea of the DSM directive, but not the part which is still covered by the Information Society directive. And to the German understanding, under the Information Society directive, there's no general recommendation not or against remuneration. So actually, the German legislator did not see any reason to exempt also the making available part from remuneration. However, of course, there are institutions and research institutions which argue against remuneration in general in the context of text and data mining. But I think it is actually the reason behind is actually the coming into being of this provision. So as long as it was only covered by the Information Society directive, it was in its entirety subject to remuneration, and the part which is now covered by the DSM directive, there the German legislator followed the recommendation of the DSM directive to exempt reproductions from remuneration. That is, I think, the whole, let's say, more historical rationale of this situation.
Najlepša hvala za pojasnilo. Besedo predajam za vprašanje gospe Špeli Stres.
Ja, hvala lepa, Petra. It's more of a comment and a brief clarification request on the process of the conformity check. The EC initiative to execute a separate conformity check, I think, is very much welcome, in order to also steer the national debates we're having away from repetitive discussions on whether the Slovenian implementation is or is not in line with the directive. So how will the stakeholders be informed about the outcome of this conformity check? Thanks.
Yeah, thank you for this question. The conformity check takes a bit of time, as you can imagine, but it will be published as any kind of a studies that Commission carries out. So once it's finalized and ready, it will be available basically online and published. And we will, like we always do, present some news item article about this with links. So hopefully it will not skip attention to people that are interested. But again, we are at the beginning of this process, to be honest, because we started with prima facie check, which is not very detailed. And as you know, some member states were even referred to the Court of Justice because of the delayed transposition. But now it's time indeed to start looking more into details. But the process just started. But at the end of it, it will be concluded with a study that will be published.
Well, thank you so much. And the expected timeline for the study to be published is approximately?
Yeah, it's difficult to say at this moment. I think study will last a year. So after this, there will be a little bit time to wrap up the results, the published work, and basically around a month or 2 months after the finalization of work by the contractor, we can expect. But again, this is with a preliminary kind of indication at this point.
Okay, thank you.
Hvala. Še kakšno vprašanje? Časa imamo dovolj. Ker smo pričakovali vprašanja, smo rezervirali dovolj časa, da bi vsi prišli na vrsto. Če pa ne, potem se bomo držali, ne glede na to, da imamo več časa na voljo, tudi urnika, in bomo odmor zaključili ob 11:30. Tako da še zadnja možnost za vprašanje za ta prvi del. Ne? Potem se bi pa na tem mestu izrecno zahvalila gospodu Kristofu Ničinskemu, ker, kot razumem, v drugem delu ne bo sodeloval. Najlepša hvala za vaša pojasnila in obrazložitve. Vse ostale pa vabim, da se nam pridružite ponovno po odmoru ob 11:30. Najlepša hvala in se vidimo. Rada bi še pred začetkom opravičila državnega sekretarja Židanja. Žal ne more biti z nami tudi na drugem delu, ker je moral zaradi nujnih drugih obveznosti se posloviti od nas. Nas pa vse lepo pozdravlja in nam želi dobro nadaljevanje. Tako, sedaj vabim, da svoj prispevek pove gospa Aleja Lopez de San Román z Evropske komisije. Gospa de San Román, izvolite.
Thank you very much. Good morning, everyone, and thank you very much for the invitation to be here today. Apologies, I couldn't stay for the whole previous session because I had to join another meeting, but I'm here now. So I understand I should share my slides. So I will be presenting open science in relation to copyright and what we are doing in the European Commission. My name is Aleja López de San Román, and I'm a legal and policy officer in the Open Science Unit in the Research and Innovation at the European Commission. So what is open science? Open science means sharing knowledge and tools as early as possible, not only between researchers and between disciplines, but also with society at large. And open science improves the quality, the efficiency and creativity of research and the trust by society in science. In particular, open science is beneficial for science, scientists and funders, for example, in tackling the reproducibility crisis, in making a faster response to societal challenges, fostering access to and sharing results that yields higher impact through collaborations, generating new research findings and decreasing inequalities, and because it has many opportunity costs of not having open science and in particularly fair, findable, accessible, interoperable and reusable data. So from the European Commission, we are embracing open science as the modus operandi of research. And we are working in two main instances, in improving the practice and in developing the enablers. Improving the practice by providing full and immediate open access to research outputs, such as scientific publications, research data, software, by fostering research output management, also publications, data, and other outputs in line with the FAIR principles that I mentioned before, findable, accessible, interoperable, and reusable, and by fostering early and open sharing of research. For example, through pre-registration, by ensuring the verifiability and reproducibility of research outputs, and by fostering open collaboration. We are also working on developing the enablers for open science, by working on the incentives and rewards to adopt open science practices, for example, the initiative for reforming research assessment, by working on the legislative and regulatory framework for practicing open science, and by developing and contributing to the development of open research infrastructures and skills. For instance, via the European Open Science Cloud, virtual research environment, via an Open Research Europe, the open access publishing service that we put at the disposal of our beneficiaries, or by supporting skills and education for practicing open science and data-intensive research. So let's now move to open science and intellectual property rights. We have the understanding that there is no incompatibility between IPR and open science. On the contrary, the IPR framework, if correctly defined from the onset, becomes an essential tool to enable open science and ensure that the efforts from different contributors are correctly rewarded. Here I'm putting a quote from the all European academies, in which they also share that understanding that there is no fundamental opposition between the ideals of open science and the valorization of research through the assertion of intellectual property rights. Intellectual property law provides the necessary legal framework within which open science can be implemented. There are often some misunderstandings about what open entails. Open scientific results are not necessarily unprotected by intellectual property. A work available in open access can be protected by copyright and related rights. For example, a data set that is made available open access under a CC BY, a Creative Commons Attribution license. There can also be scientific results that are not protected by copyright and that are available in open access. And by assigning open licenses to their work, copyright holders, when copyright protection exists, set the condition under which their work can be reused. Very importantly, an adequate intellectual property management lies at the very core of open science. And an adequate management needs a comprehensive view and understanding of IP that includes not only patents, but other IPRs, including copyright. And since the focus of this session is on copyright, I will now move to open science and copyright. What are we doing to ensure an adequate management and legislative framework that enables open science? We are working on an adequate copyright management and on an adequate copyright legislative framework. With regard to an adequate copyright management, as you well know, the Commission has different tools at its disposal. So we are working via different tools in order to foster adequate copyright management. For example, via our funding program for research and innovation for the period 2021-2027, Horizon Europe, by setting Horizon Europe provisions, on which I will later elaborate. Another example is the recommendation on access to and preservation of scientific information that we adopted in 2018 with recommendations for the member states and addressing copyright. Another example of fostering adequate copyright management by the European Commission is the integration of open science within broader intellectual property strategies that we are developing. And a fourth example is by funding capacity building. I will then elaborate briefly on each of these points. And also, very importantly, we are also working in order to have this adequate copyright legislative framework in the context of the European Research Area Action 2. So with regard to an adequate copyright management and the provisions that we have in Horizon Europe, Horizon Europe, as I mentioned, is the framework program for research and innovation for the current period. And there, our beneficiaries shall ensure that they or their authors, because the beneficiaries can be researchers, but also their institutions. So depending on the national legislation, they will have to ensure that they or the authors retain sufficient intellectual property rights to comply with their open access requirements. This is set in the Horizon Europe regulation. What are those open access requirements? Beneficiaries must ensure that at the latest open publication, either the final peer-reviewed manuscript accepted for publication or the final published peer-reviewed version is deposited in a trusted repository, and that immediate open access is provided to the deposited publication via the repository under a Creative Commons Attributions license or equivalent license. For long text format, we allow CC BY and C and D, or the combination of the two. So this is the obligation that our beneficiaries have, and they shall retain sufficient IPRs to comply with this obligation. This is what we call the open access prior obligation. The obligation to ensure open access under the conditions set out in the grant agreement that I just mentioned precedes any subsequent publishing agreement and is therefore a prior obligation with respect to such agreements. This is a recent annotation that we have published in the Horizon Europe annotated grant agreement, that it was published, the revised version of the draft annotated grant agreement 2 weeks ago. We have also recently published several questions and answers on this open access prior obligation, that is just some clarification of the obligation that our beneficiaries already had, just to respond to some frequently asked questions. If we then move to the second example with regard to fostering adequate copyright management, we can refer to the European Commission recommendation on access to and preservation of scientific information adopted in 2018, and in which member states should set and implement clear policies as detailed in national action plans for the dissemination of and open access to scientific publications that result from publicly funded research. As set in this recommendation, member states should ensure that as a result of these policies of action or action plans, researchers, when entering into contractual agreements with scientific publishers, retain the necessary intellectual property rights to comply with the open access policy requirements. Member states should also ensure that research funding institutions responsible for managing public research funding and academic institutions receiving public funding implement the policies and national action plans in a coordinated way by, amongst others, providing guidance to researchers on how to comply with open access policies and supporting them to do so, especially regarding the management of their intellectual property rights to ensure open access to their publications. So as we have seen, we have this adequate management of copyright in the obligations that our beneficiaries have in Horizon Europe, and also in the recommendations that we put forward for the member states in the 2018 recommendation. A third example of how the European Commission is promoting the adequate management of copyright to foster open science is through the integration of open science within the broader IP strategies. That was a recommendation that came in the report Open Science and Intellectual Property Rights, commissioned by the European Commission and authored by Javier de la Cueva and Eva Mendez, on which you can see the quote on the screen, underpinning EU policies with a new open science, open innovation paradigm. And it's also something that we can see, for example, in the recently adopted Code of Practice on the management of intellectual assets for knowledge valorization in the European research area, published in March 2023, and in which it is encouraged that intellectual assets are managed in a way to enable open science and open innovation. And then several recommendations follow. So this integration of open science and the adequate management of open science in the broader IP strategies, in the broader IP agenda. And the fourth example of how the Commission is fostering the adequate management of copyright to enable open science is by supporting capacity building on IP management to support open science. Here you can see, for example, a call that is currently in the work program in the Widera part on capacity building on intellectual property management to support open science. This action aims to increase the understanding amongst the research community of intellectual property assets and the role as enablers of open science, including an analysis of how adequate IP management enables and boosts open science, providing specific training materials, modules, or courses on IP assets and open science, gathering experiences and sharing good practices, or amongst other via an awareness raising campaign on how an adequate IP management enables and fosters open science. So now moving to the second strand, with regard to an adequate legislative framework on copyright that enables open science, here we can refer to the European Research Area Policy Agenda 2022-2024, as set in the Council conclusions on the future governance of the European Research Area that were adopted in November 2021. There is a list of 20 European Research Area actions, and ERA Priority Action 2 is about proposing an EU copyright and data legislative and regulatory framework that is fit for research. There are two main outcomes of this ERA Action 2. First, to identify the barriers and challenges to access and reuse of publicly funded research and innovation results and of publications and data for scientific purposes, to identify potential impacts on research through an analysis of relevant provisions under EU copyright and data legislation and the related regulatory frameworks, and of relevant institutional and national initiatives. And on the basis of that identification, to propose legislative and non-legislative measures to improve the current EU copyright and data legislative and regulatory frameworks. So as you can see, this ERA action covers both EU copyright and EU data and digital legislation, access and reuse of publicly funded research and innovation results, and access and reuse of publications and data that are needed for research to take place. What have we done under this action? The main ERA Action 2 deliverables in 2022 have been the publication of 4 independent expert studies on EU copyright legislation and access to and reuse of publications and data, and 2 on the possible impact of EU data and digital legislation and research. So 4 independent expert studies, 2 on copyright, 2 on data and digital legislation. We published them in August 2022. You can see there the screenshots, and they are publicly available in the publications office website. We also organized 2 workshops in 2022. In June, one on EU copyright legislation and access to and reuse of publications and data, and a second one on the possible impact of EU data and digital legislation on research. What are the actions in 2023 in this framework of ERA Action 2? The workshop that we held in February on an EU copyright and data legislative framework fit for research, barriers, challenges, and potential measures, and an upcoming study to evaluate the concrete effects of EU copyright framework on research that will include evidence and data gathering literature review, consultation, interviews, data and evidence gathering on concrete impacts on researchers, research funding and performing organizations, and on other affected stakeholders, including copyright right holders. This study will also further elaborate on areas in need of improvement, and this study will evaluate the effects of potential interventions. So this is the focus of the study with regard to copyright for the upcoming study in 2023. And just to finish with a last slide, what is the overall objective of our work under this ERA Action 2? A European research area in which scientific knowledge and technology circulate freely, as ambition in Article 179 of the Treaty of the Functioning of the European Union implies that scientific outputs are accessible and reusable, and that access and reuse of data for research purposes is supported. So here we see both the output side, scientific outputs that result from the research process, but also the input side, access and reuse of data that is needed for research. That the research community should have the autonomy and control over its scientific activities and results, and should retain ownership of its scientific production. An empowered and responsible research community is the bedrock on which such a European research area is built, and an adequate legislative and regulatory framework which is fit for research is a necessary condition to deliver on this objective. Thank you very much.
Najlepša hvala za vašo predstavitev. Sedaj pa predajam besedo gospe Anne Lemavon z francoskega ministrstva za kulturo.
Yes, thank you. Is it okay? Do you hear me?
Yes.
Yes. Okay, thank you. Well, actually, I will be brief. We also had internal reflections on open science and lots of discussions between the researchers and the Ministry of Higher Education and Research and the right holders, and all these discussions ended up in a legislation which was adopted in 2016, where we have a secondary publication for science financed partially or mainly by public funds. And so the way it works is we distinguish the scientific writings and the scientific data. So as far as the scientific writings are concerned, when the research has been financed at least half by public funds, then the researcher retains the right to make the research results publication available freely on a dedicated platform in two conditions. Either if the publisher itself publishes freely on such a platform, or if it's a more traditional publisher which made a normal, well, what is normal? A traditional publication of the scientific articles, then after a certain embargo period of time, parallel to the exploitation made by the publisher, the researcher may, as I said, make available freely on a platform the results of its researchers. The embargo time is different according to the scientific era area, yes, the researcher is working in. So we have 6 months embargo for a publication in the field of science, technology, and medicine, what we call hard science in French. I don't know if it's the same in English. And the embargo time is up to 12 months in the field of humanities and social sciences. So it means the publisher has either 6 months or 12 months to recoup the investment of the publication, and after that delay, then the scientific writing can be made available freely to the public if the researcher wishes so. So key word for that is the will of the researchers and the well, the how do you say that? This piece of legislation, is a sort of the most balanced system we could find in France, in favor of open science, but also letting the French publishers network be able to continue to make its work and having a diverse publication network and also a network of publications which is of high quality because made by professionals. So that is the result we had in the year 2016. The text was a very, very broad text, which was called the Digital Republic Law. It was very ambitious, so to say, and that is what we ended up as regards scientific writings. For data resulting from the research, it's a bit different because the data can be made accessible as soon as possible, so eventually immediately if it's not protected by a specific right or specific regulation. Since the year 2016, there are reflections going on. What is the latest state of that reflection? We had an advice from the book mediator on scientific publishing and open science, which was actually published last Friday. So I read it very briefly, but it ended up saying that we should keep on combine proper quality publishing, but also striving to open science policy. So still this idea of sort of a balance between the fact that the researcher can be can make the choose. Can make a choice. So he can choose either to keep all the rights or to go to a traditional publisher, but after a certain time, which is quite short, then he can give all the results and not only the results, but also the writing accessible freely to everybody. So that is the advice of the book mediator, to keep on discussing toward that goal. And now on the side of the French government, we have a new mission from, we have a higher council for copyright placed next to the Ministry of Culture in order to advise the Ministry of Culture about all, all subjects we want to. So it can be how to implement a text, or if there's a new subject, we gather all the stakeholders and they reflect on how copyright is involved in, let's say, AI or metaverse or TDM or whatever. And so we have a new mission actually on open science and publishing. And the aim of that mission is to make a review of our legal framework, analyze some evolution proposals, and also check the consequences on the way the researcher can keep the not the right, but he can still how say that? Sorry, I wrote it in French and I have a how the researcher can still decide on the way his research can be published. And now maybe I have a question to the Commission, and that's going to be the end of my presentation. Our mission is going to end by the end of this week. I heard the Commission has also a study going on for the year 2023. When does the Commission intend to finish its mission, so that maybe we can contribute with our own mission on that? But you can reply at the question and answers time. I don't want to change the whole program, but that was my question, and we would be happy to contribute also with our way of thinking. And thank you anyway for giving me the floor and for listening.
Najlepša hvala. Morda, če komisija takoj odgovori, če želi, oziroma predstavnica komisije.
As you wish, maybe easier that I quickly respond to that. So it's about, if it's fine for you, I can easily take that one now. It's about when we are planning on delivering, right, Anne? So many thanks for all the information provided. So what I presented, so as you saw, on adequate management of copyright for open science is something we are working for many years across different tools with regard to the legislative framework and the ERA Action 2, that is part of the ERA Policy Agenda 2022-2024. So I presented what we did 2022, what we have planned for 2023, and then let's see in 2024. But this is the original schedule, but this would be, as you saw, the main outcomes to identify the barriers and challenges, and then to propose potential legislative and non-legislative measures. So I would say the time frame for that, according to the ERA Policy Agenda, would be 2024 to deliver on that timeline. Then let's see, it's also indicative timeline, I would say.
Hvala za pojasnilo. Sedaj pa k besedi vabim gospo Sophie Neumann z Nemškega zveznega ministrstva za pravosodje.
Thank you. So with regard to open science in relation to copyright, the German Copyright Act basically does contain one provision. Of course, it contains other provisions facilitating the use of copyright-protected works in science, or even authorizes the use of parts of them that were the exceptions and limitations in this area that were object of part 1 of this meeting. But when it really comes to what is generally considered as open science, it does contain a secondary publication right. And this secondary publication right will be the subject of my presentation now. So section 38, paragraph 4 of the German Copyright Act provides a secondary publication right for the author. This right, however, is subject to certain conditions, which in fact, you will see it right now, are quite similar to the one under French law. So it must be a scientific contribution which results from research activities that were at least half publicly funded. The scientific contribution was reprinted in a collection which is published periodically at least twice per year. 12 months after the first publication have expired, and there German law does not make a differentiation between natural sciences and human sciences. The contribution is to be made available in the accepted manuscript version. The making available of the contribution, which the author is allowed to, is not allowed to serve a commercial purpose, and the first publication is to be cited. What is maybe the most important aspect is that the secondary publication right, according to German law, is a right of the author. It applies even if he or she has granted the publisher or editor an exclusive right of use. Any deviating agreement to the detriment of the author is ineffective. It is not a limitation. It is a provision applying to the contract between the author and the publisher. And the secondary publication right is supposed to balance the interest of the author to make his or her scientific contribution available to the scientific community and to open it for reuse and further development for non-commercial purposes, which is very important, with the interest of the publisher to protect and recoup his or her investment. And that is, as a basic outline, the secondary publication right in Germany, which is quite narrowly defined in German copyright law and is a right of the author and not a limitation. And it's more like a contract law provision applying to the relation between author and publisher. And that would be it for now. Thank you.
Najlepša hvala. Sedaj pa je na vrsti še gospod Jakob Slovak, Slovaškega ministrstva za kulturo. Jakob, prosim.
Thank you very much. I would be also very brief, but I have prepared also very few slides related to the open access and open science in Slovakia. So I will continue sharing my screen in a minute. Can you see it now, please? Okay, great. Thank you very much. So as a very short introduction, I would like to say that the Copyright Act and any provisions in the Copyright Act do not differ between the situations whether the research or science is funded from private or public resources, but we have one very specific provision in the Copyright Act, which is related to so-called public licenses, or these public licenses were introduced in the Copyright Act at the beginning of 2016. So since January 1st, 2016, this provision is included in the Copyright Act. It's a very short article about these public licenses, and the basis of these public licenses is that author can offer granting or can grant license towards an unidentified number of persons. So it means that author can offer license, for example, in the digital environment, on the internet, and he or she do not know in advance to whom he offered this kind of license. Then, as a second step, a conduct from which consent with these terms of license may be derived constitutes the acceptance of such offer or of such license. So if the person, for example, in the online environment, click on some terms of license that he or she accepted them, then this is considered as a conclusion of the license. Author may grant also a license for the type of use which is not known at the time of concluding such license agreement. So this is very specific provision, because this is only allowed under these public licenses. It's not allowed under general provisions regarding the licenses. And another important provision is that public license may only be granted as a non-exclusive and free of charge license, and it cannot be revoked. In general, this public licenses allows using Creative Commons licenses, general public licenses, and other types of licenses, and it can sometimes be also related to open access and to the open science topic. As was pointed out by the Commission in its presentation, also in Slovakia, there is a development of so-called action plans for the open government in the Slovak Republic as such, and it includes some missions or some steps also related to open science and open access. The first such action plan was prepared in 2015, and since then, almost every biennium, the action plan has been renewed. The missions and the steps are evaluated, or they continue from the biennium to biennium, and it goes in this way. The action plan for the open government is prepared by the Ministry of Education, Science and Research of the Slovak Republic in consultation with many other subjects, with various universities, academics, research centers, of course, sometimes in consultation with other subjects like Ministry of Culture, but it's not specifically Ministry of Culture who is in charge of this, but it's the Ministry of Education, Science and Research as a main institution or state body responsible for this topic. Recently, some measures from this recent action plan, which was last time for the biennium 2021 and 2022, some measures were realized, but they were not in relation to the copyright and related rights. These realized measures related mostly to registers, to financing schemes, to subventions, to various study programs, because it covers large number of issues, this action plan. So it's not specifically related to IP rights or copyrights only. Of course, in some consultations with us, with the Ministry of Culture, it was assessed that copyright is not the barrier for the open science and open access in Slovakia. So that's the main idea. When we consulted, we find out that there are no big barriers on the copyright side for the open science and for open access. Nowadays, the new action plan is being prepared for the biennium 2023-2024, but there are some steps already prepared. It has some form, but its adoption is delayed due to the fact that there will be election in Slovakia and new government will be elected probably in September or October. So after that, the new action plan should be probably approved. Yep. Another issue that relates to the open science and open access is what I already said, that Ministry of Culture has not identified any barriers within Copyright Act. with regard to open access for the research outcomes. But in general, when we studied some steps in the action plan and when we consulted with the Ministry of Education, it's clear that the receiver of the subvention, for example, academic institutions or researchers, they has to clear the rights with all the right holders in order they can further apply this public license that I mentioned at the beginning of this part of presentation. It's very important to note that this clearance of right has to be especially the fact if the research activities are exercised through international cooperation. So when there is some kind of cross-border element. But once the receiver of the subvention or the receiver of this public funding has the rights, it can further apply the public license, which is allowed under the Slovak Copyright Act. Then there is other important provision. It's the provision about the employee's work, because employer, for example, university or Slovak Academy of Science, because those institutions employed many researchers or many academics, these employers can exercise the economic rights to the employee's work on the basis of the Copyright Act. In general, it means that such employer can grant public license without the employee's authorization. So if a researcher creates something as an employee of the university or as an employee of the Slovak Academy of Science, then this institution, the employer, can grant public license without the employee's authorization. However, shortly conclude, I have to say that still, even on the basis of these action plans, the principles of open science are still not fully developed and fully used in Slovakia. Mainly, it's due to the fact that the infrastructure for the storing and making access to the research outcomes or outputs is not still very much developed, but I have to say that slowly, step by step, it's developing, and we hope that we soon reach some kind of final stage. And once again, we check whether we can do something in the copyright area, what can help for this open science and open access, of course, in line with also the Commission's steps. So public licenses are still not fully used by the research institutions. That's because mainly of the infrastructure, as I said. And just to conclude, in comparison to what has been said by France and by Germany, there is no secondary publication right in Slovakia. So I would not go into any details. I cannot go into any details of this. Thank you very much.
Najlepša hvala vsem našim govorcem. Sedaj smo prišli do konca drugega dela in ponovno je čas za vaše vprašanja. Če želite zastaviti vprašanje, dvignite roko. Gospa Maja Bogataj Jančič, prosim.
Najlepša hvala, Petra. Thank you very much. I would have one question for Ms. Alea Roman regarding the secondary publishing rights. Thank you to German and French presentations to mention this very useful provisions in some national laws. So Slovenia does not have this provision. I think that 6 members in the European Union already have these provisions, and my question is the following. Firstly, what is the main advantage for open science to have such provision in the national legislation?
versus to just imposing management obligations from the side of funders? That would be the first question. And the second, if a national legislator in Slovenia would want to model or would want to design a secondary publishing right provision in our law, from your perspective, which are the provisions in European Union that it's worth looking at them and get some useful inspiration for open science when drafting this law? Thank you very much.
Thank you very much, Maya, for your questions. So with regard to secondary publication rights, indeed, we very much welcome the introduction in national, I will slow down for the translators, the introduction into national legislation of those secondary publication rights. I count 5 member states having introduced those. You mentioned 6, but I would count Austria, Belgium, the Netherlands, France, of course, and Germany.
And Spain?
Spain, in the Article 37 for the Law for Science, I see an obligation to deposit and provide open access, but indeed, let's see. Yes,
let's talk about 5 then.
Yeah, no, I don't know, maybe, but depending on how the Spanish national authorities interpret or refer to it, but I will refer to these 5. And the main advantage, your question with regard to this secondary publication right, instead of a mandate, for example, as the one we have in Horizon Europe, is that our mandate is for our beneficiaries. It's an obligation for our beneficiaries, in our case, Horizon Europe, while the right is a right that all researchers, let's say, in a given country, or if we talk about the European level, they could have. Also the difference between an obligation and the right to provide open access, that is quite significant. For example, what I mentioned in Horizon Europe, that now we are emphasizing this prior obligation that our beneficiaries have, is because they can still infringe or breach this obligation. If they go and sign a publishing agreement that sets conditions that will not allow them to comply with the obligation, they can still not provide open access and under the conditions we ask for, while with a right, you have the right to do so. And with regard to the national legislator in Slovenia, insofar as we are concerned, we are still analyzing the different secondary publication rights introduced at the national level, because there are several differences, as you very well know, between them. AAM, version of record, reasonable period, the length. So I wouldn't dare to advise which one is useful as a source of inspiration. We are still undertaking our analysis and also taking into consideration national experiences, but also the calls by stakeholders, for example, of LIBER, the research libraries, for the introduction of a secondary publication right at the EU level, all European academies, also some months ago, calling for such an introduction at the EU level. So we are still in the analysis phase in what are the drawbacks and benefits of the different approaches. But certainly, we very much welcome the introduction that member states have done at the national level of secondary publication rights, in that they really enable open access to publicly funded scientific publications, publications resulting from publicly funded research.
Thank you very much. And maybe in the near future, Slovenia will be the best role model for secondary publishing grant. Let's cross our fingers. Thank you.
Looking forward to it.
Najlepša hvala, gospa Mojca Kotar. želi zastaviti, prosim?
Dober dan, najlepša. Thank you very much.
Lahko v slovenščini.
No, it's
Lahko v
okay.
sloven-
I can manage in English. Thanks a lot. So Mojca Kotar, University of Ljubljana. I think that secondary publishing right is really helpful for researchers because it's usually quite difficult to deal with publishers regarding open access. But the Slovenian legislation now says, research legislation, that open access publications or actually research results from publicly funded research need to be available immediately. It's different for research data, as open as possible, as close as necessary, but publications immediately. So this is in line with European Research Area and Horizon Europe. Now, if secondary publication right allows for embargo, let's say 6 or 12 months, this is actually the breach of legislation in Slovenia. So how do we adjust? It's helpful, definitely, for researchers, but it should be without embargo. Sorry for such a difficult question.
Bi kdo želel odgovoriti na to? Gospa Lopez de San Roman?
So I understand that it's up to, in the case of national provisions on secondary publication right, that is a decision made by the national legislators to introduce embargo, as we heard from France, for example, and also Germany, as a way to achieve a balance. But I understand that it's a choice that has been made, the setting up of the embargo period in the secondary publication right by the national legislators when introducing that approach.
Hvala. Še kakšno vprašanje morda? Gospod Grubar, imate vprašanje? Maja, prosim.
Thank you very much again, Petra. I have one question for Jakub from Slovakia. Mr. Jakub, you mentioned that in your legislation there are no barriers to open science, but then in the second part of your slide there was a specific mention that you have this provision, I assume it's presumption of transferring of rights from employer to employee. And you didn't explain it into the detail, but my first question is whether the transfer is exclusive or non-exclusive. I'm asking this because we have similar provision in Slovenian law as well. And in cases when transfer for 10 years is according to Slovenian law is exclusive, I see this provision as a pragmatical barrier to open science in our law, because it can hinder the legitimate management of rights. I will explain to you in this detail. For example, teacher is employed at school or scientist is employed, researcher at university, and researcher, when works under the scope of employment with the equipment of employer and under the obligation of this employment produces something, then presumption kicks in. So the material part of the rights transfers to the employer, but researcher still uses open license to manage the results of his creation. So on many occasions, research community here proposed to change our provision and to say for not just for 10 years, but forever, but not exclusive, but non-exclusive, because it would cure this problem. So this long question and additional explanation is targeted to you, whether you see this provision, if you have the same as a little pragmatical barrier to open science in your legislation. Thank you very much.
Thank you very much for the question raised. Yes, of course, it's non-exclusive because these economic rights of the author can be transferred to the employer, but they can agree. There is the provision that says unless otherwise agreed. So the employee and the employer can agree on some specific conditions of how to exercise these economic rights between employer and the employee. So of course they can agree on some specificities, and they can limit somehow the further licensing of the work that is created under this employment regime, as we call it. Yeah, this is one of the possibilities. So it's not some kind of barriers, but of course the author or the employee has the possibility to somehow limit this employer regime. So that's, I don't know whether this replies directly to the questions. Thank you.
Thank you very much. And can you mention what is the number of the article in your law that regulates this presumption of employee-employer? If you know it by heart, otherwise, please, I will try to look.
It's Article 90. It's Article 90 of the Copyright Act.
Thank you very much. Thank you very much.
Hvala. Gospa Lopez de San Roman.
Yes, just very briefly, also related to the importance of copyright retention. For example, in our annotated grant agreement for Horizon beneficiaries, we explicitly indicate as a best practice that authors or their institution, depending on the national legislation, retain their copyright insofar as possible, and they grant non-exclusive licenses to publishers. And we also recommend as a best practice that institutions adopt policies to foster this copyright retention. So indeed, copyright retention plays a very important role in enabling open access, and in our case, in enabling compliance with the open access obligations.
Najlepša hvala. Imamo morda še kakšno vprašanje? Potem pa se zahvaljujem. Maja, še eno vprašanje?
Well, I do
Še
want
zadnje vprašanje, ja.
I do want to use as many opportunities as possible, because it's not many times that we have such a distinguished speakers here. One question to Alea in relation to the presentation that took place in the first part, but I don't know whether you were present the whole time. Miss Lamorvan, I'm sorry, I don't speak French, it sounded terrible, presented the exceptions and limitations for research and scientific research for illustrative purposes, and mentioned the French solution, which offers extended collective management to balance introduction of this exception. For many member states, this presents quite a huge difference and break with the tradition that we currently have. And I personally think that compensation for such purposes reaches a little bit too far, and also introduction of extended collective management in this sector is really introducing something from Scandinavia in environments that are not really cope very well with this. So what is your opinion about that? I mean, it's at the end of the day, it's up to the states to decide whether to introduce that or not. But are there any other countries, if you know, of course, in Europe that are introducing extended collecting licenses mechanism for exception for illustration for scientific purposes? So basically meaning introduction of compensation in these cases. And what's the opinion for DG Research on this topic? Thank you very much. You're muted.
Thank you very much, Maya. So unfortunately, I did not hear the presentation of Ms. Anne Le Morvan because I had to leave to another meeting. With regard to the opinion, so not on that presentation because I couldn't listen to it, on other examples of extended collective license mechanisms, it's something that we would need to look into. So looking forward to knowing more about the topic, but I'm not in a position now to comment on that, I'm afraid. Thank you.
Thank you, Lea.
Anne?
Yes. To go back to what has just been said, there is a distinction, but probably I wasn't clear enough. As regards the exception for illustration during, let's say, class, which is not class, but a seminar or whatever, for researchers and for higher education, we have the classical exception from the InfoSoc directive, but compensated. And we have extended collective licenses only for the very specific item of using images, photos, or whatever in the publications of scientific research, because we think there is no exception with that scope in the EU framework. And so we cannot have an exception because it's not listed either in the InfoSoc directive, and it's not covered in the DSM directive, because the DSM directive organized something for educational research, for educational exception, but did nothing on research exception except TDM. And so that's why we went to extended collective licenses, because otherwise, well, yes, just to repeat myself, it was not possible to have an exception and to let the normal play of licenses seemed to us a bit complicated and a high cost of negotiating, not be sure that you have the whole repertoire you need for the researchers, and that's why we decided to have that. But okay.
Thank you very much.
Hvala. Morda še kdo? Priložnost še za zadnje vprašanje.
Maybe I will have two questions, maybe. First question is who pays for the use of other authors' materials for teaching or research purposes, or researchers, or a teacher, or academic institution, or ministry? This is for German and for France.
Okay, Sophie, I start.
Okay.
In France, the system is the ministries are paying for that. So the Ministry of Education is paying for the exception, for the compensation of the exception for school purposes, and the Ministry for Higher Education and Research is paying for the compensation of the exception on research.
Yes, so I may add to the German situation. So in Germany, it's basically it's not the school itself, but public schools belong to a city or regional state or federal state, and it's always so the city, the regional state, or the federal state who is paying in the end. And also for the negotiations all the, let's say, state bodies on local, regional, and federal level are represented by a special, let's say, task force of the Kultusministerkonferenz. So it's actually a body representing the different local, regional, and federal authorities in Germany. So in a first step, it would normally be the school, but schools and universities are all publicly funded. So in the end, it comes actually to the city, regional, state, or federal state with funding a school or university or other research institution. Thank you.
Hvala. Še kakšno vprašanje?
The next question, or the last question, my question is about, for example, if I have a data set and I license this data set with CC BY license, for example, and I don't want to have some, how I say, payment for my data set. What is in this case? Because I think in author law, copyright law, you have different, how I say, definition.
Bi kdo želel odgovoriti na to vprašanje? Gospod Ojsteršek, ste želeli nasloviti to vprašanje konkretno? Aha. Ja.
Yes, I wish, how I say, explanation how we will, in this case, how we will react.
Se pravi, vprašanje je bilo naslovljeno na slovenskega, na urad, oziroma...
I think on all to Slovenian intellectual property rights and also to European level. If I don't want to have payment for my work, then but in legislation it's possible to pay for every intellectual how I say, work.
Ja, gospa N. Lamavon je imela roko gor, tako da če želite odgovoriti, vi?
Yes. What is negotiated is a very general amount for all the users. And so I'm sure I haven't been there during the negotiations, but what I know from other negotiations is that the user is trying to pay for the exact uses he needs an authorization. And so I think the different ministries, so for education and for research, probably put on the table the fact that, I don't know, 30% of the material used is covered by Creative Commons licenses, and so they don't have to pay for that. Then there is a second step, which is that's the collection of the money and the general amount paid for the compensation. So I think it's taken into account at that stage. So say a big part of what we need is not under rights or is under a Creative Commons license. So we want to pay it. And so it lower the remuneration the compensation, sorry, the ministries pay to the right holders. And after that, there is a second step. I don't know for where the CMO pays the different right holders. So probably they don't pay the ones which made the articles under Creative Commons. But that, to be honest, I don't know. I should check, but I don't have the information by now.
Najlepša hvala. Jakob?
Thank you. I will just reply very, very briefly. This would be the case that will directly fall according to the Slovak legislation under the public licenses, because anyone can grant, for example, Creative Commons license. And if there are some conditions, if there is no need for the payment, it can be set. And on the other hand, the basis for this public license is that it should be free of charge license and non-exclusive. So it would directly fall under this. Thank you very much.
Hvala. Predajam besedo Mojci Pečar.
Hvala. Kar se tiče kolektivnega upravljanja, pričakujemo, da imetnik pravic, ki bi dal uporabo svojega dela pod prosto licenco, niti ne bi prijavil v kolektivno organizacijo. Kar se tiče definicije kot take, oziroma višine zneska, ki bi se plačal, pa je stvar pogajanj med ministrstvom, ki je pristojno za izobraževanje, in uporabniki, v kakšni višini bodo določili ta splošen znesek. Kot veste, zaenkrat nadomestilo za uporabo del pri digitalnem poučevanju oziroma poučevanju v digitalnem okolju še ni zaživelo in je predvideno, da se uresniči s 1. septembrom 2024.
Mojca, hvala. Gospa Pogačnik.
Ja, jaz bi samo dodala kot dopolnilo odgovoru gospe Pečarjeve, da Združenje ZAM, ki je seveda pristojno za izplačila kot kolektivna organizacija za izplačila del znanstvenikom, tudi med drugim na področju književnosti, znanosti in publicistike, bo seveda, ko bo dosežen dogovor, ustrezno izplačalo pravice imetnikom. Samo v informacijo, tako da bo gospod pač seznanjen z tem, da seveda tudi mi pričakujemo, če bo pač karkoli ustrezno dogovorjeno, da smo sposobni pač to izvesti. Hvala lepa.
Hvala za to pojasnilo, gospa Pogačnik. Čas za vprašanja se je iztekel. Direktorica Urada za intelektualno lastnino, magistrico Karin Žvokelj, prosim za sklepne besede današnjega dogodka.
Petra, jaz mislim, da je bilo pa še eno vprašanje. Sem videla roko, preko je zaključen.
Jaz to roke ne vidim, ampak seveda.
Nekako.
Ima kdo še vprašanje?
Ok, očitno ne.
Mogoče sem jaz ozignila roko Maja Bogataj, ampak sem jo potem spustila in bom postala en link v chat za gospoda Ojsterška. Hvala vam. Hvala, gospa.
Ok, dobro. No, pa sem pa dobro videla.
Opravičujem, gospa direktorica, gospod Aleksander Govekar, vi želite, da... No, še to vprašanje. Jaz gospoda Govekarja ne slišim. Drugi slišite ali imam samo jaz te težave?
Ne slišimo, Petra.
Ne slišite. Gospod Govekar, ne slišimo vas. Ne slišimo. Žal mi je, vendar vas ne slišimo. Tako da morda bi vseeno zaključili. Direktorica, prosim.
Jaz bom imela samo eno zaključno misel. Še enkrat bi se rada zahvalila vsem govorcem današnjega dogodka. Mi na uradu smo res želeli ta javni posvet, ko smo ga poimenovali, narediti takega, da res imamo take govorce, ki imajo bogate izkušnje, znanje in da lahko skupaj podelimo in ne nazadnje tudi tlakujemo pot naprej z izkušnjami našimi in njihovimi. Ja, tako kot na Slovaškem, kot je slovaški govornik rekel, tudi v Sloveniji sploh odprta znanost, odprti dostopi, ni še v celoti vse razvito, tako da ja, gre za proces, na katerem bomo tudi pri nas mogli še veliko delati in ne nazadnje tudi ta javni posvet bo pomagal pri tlakovanju tudi te poti. Tako da še enkrat hvala za vse dragocene informacije, izkušnje govorcev, ne nazadnje tudi za vsa vprašanja strani udeležencev in se vidimo v jesenskem času, ko bomo spet imeli podoben javni posvet, bolj v smeri kolektivnega upravljanja pravic, tako da želim vam danes še en lep dan in hvala za vašo udeležbo vsem.
Direktorica, hvala. Tako, dogodek je pri koncu. Tudi v mojem imenu lepa hvala našim gostom in vsem udeležencem. Najlepša hvala tudi našima tolmačkoma za današnje tolmačenje. Posnetek dogodka bo predvidoma v nekaj dneh objavljen na spletni strani Urada za intelektualno lastnino, tako da si ga boste lahko ponovno ogledali. Želim vam prijeten dan še naprej in se vidimo na naslednjem dogodku. Nasvidenje.